Section 9 of the Watergate Report, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by John Dennison, Portland, Maine. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 1. Section N. The beginning of the unraveling of the cover-up. The cover-up began publicly to unravel when McCord broke his silence on March 21, 1972, with his letter to Judge Sirica, which was read in open court on March 23. It was soon learned that McCord had accused Magruder of perjury and Mitchell, Magruder, and Dean of participating in planning the Watergate break-in. Even before McCord broke his silence, Magruder and Dean were concerned about the viability of the cover-up. Magruder, according to his testimony, expressed his concerns to Haldeman as early as January 1973, and to Mitchell and Dean in March. Dean voiced his fears to the president on several occasions. Subsection 1. The February 28 meeting. According to Dean, he met with the president on February 28, 1973, and, after discussion of a number of matters, informed him that he, Dean, was involved in the post-June 17 activities regarding Watergate. I briefly described to him why I thought I had legal problems, and that I had been a conduit for many of the decisions that were made, and therefore could be involved in an obstruction of justice. Dean said the president did not accept his analysis, wanted no details, and told him not to worry because he had no legal problems. The edited presidential transcript of this meeting does not, in significant respects, bear out Dean's recollection of this meeting. However, in Dean's meeting with the president on March 21, he did tell the president that he could go to prison for obstruction of justice since he was acting as a conduit in the payments of money to the defendants. The president discounted this possibility, as Dean has testified, on the ground that Dean was acting as a lawyer. This conversation is quite similar to the one Dean testified took place on February 28, and it thus appears from these unauthenticated transcripts that Dean placed this discussion with the president on the wrong date when he testified before the Select Committee. Nonetheless, there are certain statements during the February 28 meeting that can be construed as referencing the cover-up, then in progress. President: I feel for those poor guys in jail, particularly for Hunt, and with his wife dead. Dean: well, there is every indication they are hanging in tough right now. President: what the hell do they expect, though? Do they expect clemency in a reasonable time? What would you advise on that? Dean: I think it is one of those things we will have to watch very closely. For example. President: you couldn't do it, say, in 6 months. Dean: no, you couldn't. This thing may become so political as a result of these hearings that it is a vendetta. This judge may go off the deep end in sentencing and make it so absurd that it's clearly injustice that they have been heavily. Dean: well, we have come a long road on this thing now. I had thought it was an impossible task to hold together until after the election, until things started falling out, but we have made it this far, and I'm convinced we are going to make it the whole road and put this thing in the funny pages of history books rather than anything serious, because actually. President: it will be somewhat serious, but the main thing, of course, is also the isolation of the president. Dean: absolutely, totally true. President: because that fortunately is totally true. Dean: I know that, sir. President: expletive deleted. Of course, I am not dumb, and I will never forget when I heard about this, adjective deleted, forced entry and bugging. I thought, what in the hell is this? What is the matter with these people? Are they crazy? I thought they were nuts. A prank. But it wasn't. It wasn't very funny. I think that our Democratic friends know that too. They know what the hell it was. They don't think we'd be involved in such. President: but I think it is very important that you have these talks with our good friend Kleindienst. Dean: that will be done. President: tell him we have to get these things worked out. We have to work together on this thing. I would build him up. He is the man who can make the difference. Also point out to him what we have. expletive deleted. Coulson's got characterization deleted. But I really, the stuff here, let's forget this. But let's remember, this was not done by the White House. This was done by the committee to re-elect, and Mitchell was the chairman, correct? Dean: That's correct. President: And Kleindienst owes Mitchell everything. Mitchell wanted him for attorney general, wanted him for deputy, and here he is. Now, expletive deleted, Baker's got to realize this, and that if he allows this thing to get out of hand, he is going to potentially ruin John Mitchell. He won't. Mitchell won't allow himself to be ruined. He'll put on his big stone face. But I hope he does, and he will. There is no question what they are after. What the committee is after is somebody at the White House. They would like to get Haldeman, or Coulson, or Ehrlichman. Dean: Or possibly Dean. You know, I'm a small fish. President: Anybody at the White House they would. But in your case, I think they realize you are the lawyer, and they know you didn't have an adjective deleted thing to do with the campaign. Dean: That's right. President: That's what I think. Well, we'll see you. Subsection 2. The March 13 meeting. Dean's testimony was that the money demands by Hunt and how to meet them and the promise of clemency to Hunt were discussed with the president and Haldeman at this meeting. This testimony is not supported by the edited presidential transcripts of this meeting. It appears from that document and Haldeman's testimony that Dean confused his morning meeting with the president on March 21, where Hunt's money demands and clemency were discussed, with the events of March 13. Nevertheless, the March 13 transcript is significant because it shows that, on that date, Dean revealed at least some of the aspects of the cover-up to the president. Some illustrative passages from the edited presidential conversations follow. President: Who's going to be the first witness up there? Dean: Sloan. President: Unfortunate. Dean: No doubt about it. President: He's scared? Dean: He's scared. He's weak. He has a compulsion to cleanse his soul by confession. We are giving him a lot of stroking. Funny thing is, this fellow goes down to the courthouse here before Sirica, testifies as honestly as he can testify, and Sirica looks around and called him a liar. He just said Sloan just can't win. So Kalmbach has been dealing with Sloan. Sloan is like a child. Kalmbach has done a lot of that. The person who will have a greater problem as a result of Sloan's testimony is Kalmbach and Stans. So they are working closely with him to make sure that he settles down. Dean: Kalmbach is solid? President: He will. How does he tell his story? He has a pretty hard row to hoe. He and Stans have. Dean: He will be good. Herb is the kind of guy who will check not once or twice on his story, not 3 times, but probably 50 to 100 times. He will go over it. He will know it. There won't be a hole in it. Probably he'll do his own Q&A. He will have people cross-examine him from 10 ways. He will be ready, as Maurice Stans will be ready. President: Mitchell is now studying, is he? Dean: He is studying. Sloan will be the worst witness, I think. Magruder will be a good witness. This fellow, Bart Porter, will be a good witness. They have already been through grand jury. They have been through a trial. They did well. Dean: Chapin didn't know anything about the Watergate. President: Don't you think so? Dean: Absolutely not. President: Strachan? Dean: Yes. President: He knew. Dean: Yes. President: About the Watergate? Dean: Yes. President: Well, then he probably told Bob. He may not have. Dean: He was judicious in what he relayed, but Strachan is as tough as nails. He can go in and stonewall and say, I don't know anything about what you are talking about. He has already done it twice, you know, in interviews. President: I guess he should, shouldn't he? I suppose we can't call that justice, can we? Dean: Well, it is a personal loyalty to him. He doesn't want it any other way. He didn't have to be told. He didn't have to be asked. It just is something that he found was the way he wanted to handle the situation. President: But he knew. He knew about Watergate. Strachan did? Dean: Yes. President: I will be damned. Well, that is the problem in Bob's case. Not Chapin then, but Strachan. Strachan worked for him, didn't he? Dean: Yes. They would have one hell of a time proving that Strachan had knowledge of it, though. President: Who knew better, Magruder? Dean: Magruder and Liddy. President: Oh, I see. The other weak link for Bob is Magruder. He hired him, etc. Dean: That applies to Mitchell, too. President: Is it too late to go to the hangout road? Dean: Yes, I think it is. The hangout road. President: The hangout road. Inaudible. Dean: It was kicked around Bob and I and... President: Ehrlichman always felt it should be hangout. Dean: Well, I think I convinced him why he would not want to hang out either. There is a certain domino situation here. If some things start going, a lot of other things are going to start going, and there can be a lot of problems if everything starts falling. So there are dangers, Mr. President. I would be less than candid if I did not tell you there are. There is a reason for not everyone going up and testifying. President: I see. Oh, no. I didn't mean to have everyone go up and testify. Dean: Well, I mean they're just starting to hang out and say, here's our story. President: I mean put the story out, PR people. Here is the story, the true story about Watergate. Dean: They would never believe it. Subsection 3. The March 21 meeting. On March 21, 2 days before McCord's letter to Judge Sirica became public, Dean met with the president to give him a report of his knowledge of the Watergate facts and to explain the implications of those facts. Dean's testimony before the Select Committee was as follows. He told the president that, quote, there was a cancer growing on the presidency and that if the cancer was not removed, the president himself would be killed by it, unquote. He told the president that the cancer must be excised immediately because it was growing more deadly every day. He then gave the president a broad overview of the Watergate affair, including a description of the meetings in January and February 1972 in Mitchell's office. He told the president he did not know how the plan was approved, but that he was informed that Mitchell and Haldeman, the latter through Strachan, had received illegal wiretap information. Dean informed the president of the highlights of the cover-up, including the use of Kalmbach by Ehrlichman, Haldeman, and Mitchell to raise hush money to pay the Watergate defendants. He spoke of Magruder's false story before the grand jury and of his role in assisting Magruder to commit perjury. He told the president that for the cover-up to continue, it would require even more perjury and more money. Certain portions of the edited presidential transcript for this meeting relating to hush money and clemency have been previously presented in this report. The following quotations provide further indication of the tenor of the conversation at that meeting. President: Magruder is unintelligible. Dean: Yeah, Magruder is totally knowledgeable on the whole thing. President: Yeah. Dean: All right now, we have gone through the trial. I don't know if Mitchell has perjured himself in the grand jury or not. President: Who? Dean: Mitchell. I don't know how much knowledge he actually had. I know that Magruder has perjured himself in the grand jury. I know that Porter has perjured himself in the grand jury. President: Who is Porter? Unintelligible. Dean: He is one of Magruder's deputies. They set up this scenario, which they ran by me. They said, how about this? I said, I don't know. If this is what you're going to hang on, fine. Dean: Now, what has happened post June 17? I was under pretty clear instructions not to investigate this, but this could have been disastrous on the electorate if all hell had broken loose. I worked on a theory of containment. President: Sure. Dean: To try to hold it right where it was. President: Right. Dean: Liddy said if they all got counsel instantly and said we will ride this thing out. All right, then they started making demands. We have to have attorney's fees. We don't have any money ourselves. and you are asking us to take this through the election? All right, so arrangements were made through Mitchell initiating it, and I was present in discussions where these guys had to be taken care of. Their attorney fees had to be done. Kalmbach was brought in. Kalmbach raised some cash. President: They put that under the cover of a Cuban committee, I suppose. Dean: Well, they had a Cuban committee, and they had some of it was given to Hunt's lawyer, who in turn passed it out. You know, when Hunt's wife was flying to Chicago with $10,000, she was actually, I understand after the fact now, was going to pass that money to one of the Cubans, to meet him in Chicago and pass it to somebody there. President: Unintelligible. But I would certainly keep that cover for whatever it is worth. Dean: That's the most troublesome post thing because 1. Bob is involved in that. 2. John is involved in that. 3. I am involved in that. 4. Mitchell is involved in that. And that is an obstruction of justice. Dean told the committee that he informed the president on March 21 that he did not believe that all of the 7 defendants would maintain their silence forever and that one or more would likely break rank. The transcripts reveal an extended discussion about various individuals capable of, quote, blowing, unquote, and about others who were, quote, solid, unquote. The edited transcripts indicate that Dean told the president, quote, I know, sir, I can just tell from our conversation that these are things you have no knowledge of, unquote. The president replied, quote, You certainly can, unquote. These last remarks are consistent with Richard Moore's testimony that Dean had said to him that the president was not aware of White House cover-up activity. According to the edited transcripts, the president shortly thereafter told Dean, President: Let's come back to this problem. What are your feelings yourself, John? You know what they are all saying. What are your feelings about the chances? Dean: I am not confident that we can ride through this. I think there are soft spots. President: You used to be. Dean said that in this meeting he told the president that because he did not think they could carry the cover-up any further, it was important for the president to get out in front of revealing the true facts. The edited transcript released by the president reveals the following exchange. President: So what you really come to is what we do. Let's suppose that you and Haldeman and Ehrlichman and Mitchell say, we can't hold this. What then are you going to say? What are you going to put out after it? Complete disclosure, isn't that the best way to do it? Dean: One way to do it is for you to tell the Attorney General that you finally know. Really, this is the first time you are getting all the pieces together. But this recommendation was not followed. Dean testified that despite his full disclosures to the president, a meeting with the president, Haldeman, Ehrlichman, and Mitchell the following day, March 22, focused entirely on the White House's relationship with the Select Committee, particularly in regard to the assertion of executive privilege. The edited transcript of that meeting shows that this was the principal subject of discussion. Dean testified that he then became convinced that there would be no effort to stop the cover-up. Subsection 4, the Camp David trip. Dean testified that on March 23, 1973, after McCord's letter was read in open court, the president called Dean and, referring to McCord's letter, said, quote, Well, John, you were right in your prediction, unquote. The president suggested that he go to Camp David to analyze the situation. According to Dean, when he arrived at Camp David, he received a telephone call from Haldeman, who instructed him to write a report on everything he knew about Watergate. While Dean indicated this was his first instruction to put his knowledge in writing, the edited transcript of the March 21st afternoon meeting indicates that the president, at that meeting, asked Dean to write a report on Watergate. Dean said he spent that day and the next thinking about the entire matter and concluded that the true facts must be publicly revealed because the situation would not improve, only worsen. He said he had several telephone conversations with Richard Moore, trying out ideas as to how the president could make the whole truth public. He said Moore seemed receptive but suggested he get Haldeman's reaction. Dean spoke to Haldeman and concluded he was, quote, intrigued but not overwhelmed, unquote, by the idea of public revelation. Dean said, quote, it was becoming increasingly clear that no one involved was willing to stand up and account for themselves, unquote. Dean, at Camp David, did write a report but decided not to give it to Haldeman or the president when he returned. Subsection 5. Dean's initial contacts with prosecutors and the Select Committee. On March 28, Haldeman asked Dean to return to Washington to meet with Mitchell and Magruder. Although Dean did not wish to do so, Haldeman insisted. Dean testified he had the distinct impression that Haldeman was, quote, backpedaling fast, unquote, that he was in the process of uninvolving himself even if it meant sacrificing others. The March 28 meeting between Dean, Mitchell, and Magruder has been discussed earlier in this report. Magruder was concerned that everyone stick to the cover-up story Magruder had given the grand jury as to the entries in Magruder's diary for the meetings in Mitchell's office on January 27 and February 4, 1972. Dean testified he refused to perpetuate this false story. On March 30, Dean retained an attorney, and on April 2, he and his attorney met with the U.S. attorneys. Dean told them he was willing to come forward with everything he knew about the Watergate affair. Shortly afterward, Dean began providing information to the Select Committee under a special arrangement approved by the committee, whereby he would speak only with the chief counsel to allow him to evaluate the information Dean could provide to determine whether the committee should offer Dean, quote, use, unquote, immunity. Subsection 6. The Ehrlichman investigation. As indicated above, when Dean returned from Camp David, he did not submit a written report on Watergate to the president or Haldeman. Because of this, Haldeman said, the president on March 30 ceased dealing with Dean on Watergate and transferred the White House Watergate investigation to Ehrlichman. It appears, however, from the edited presidential transcripts that this account of the genesis of the Ehrlichman, quote, investigation, unquote, was developed during an April 16, 1973 meeting among the president, Haldeman, and Ehrlichman. According to the transcript, the president asked Haldeman and Ehrlichman how the, quote, scenario worked out, unquote. Ehrlichman and Haldeman advised the president that the White House's position should be that the Watergate investigation was taken from Dean and given to Ehrlichman because Dean failed to write a report. According to this, quote, scenario, unquote, it was Ehrlichman's report to the president that led the president to contact Kleindienst and Peterson on April 15 to inform them of his knowledge of the Watergate facts. Ehrlichman, however, told the committee he did not conduct a thorough investigation of the Watergate matter, but only interviewed several White House and CRP officials, including Mitchell, O'Brien, and Magruder. He testified he gave an oral report to the president on April 14, 1973, that was based on these few interviews. Ehrlichman testified that after his report, the president directed him to, quote, advise the Attorney General, unquote, of his findings. Ehrlichman telephoned Kleindienst at 5:15 p.m. on April 14 and related to him the contents of his report to the president. As will subsequently appear, the prosecution already possessed much of the evidence Ehrlichman offered. Subsection 7. The attempt to have Mitchell take the blame. Dean testified that his first meeting to give information to the federal prosecutors was scheduled for April 8. He said he felt obliged to tell Haldeman of his intentions and thus telephoned him that morning at San Clemente. Haldeman advised Dean against this course, saying, quote, once the toothpaste is out of the tube, it's going to be very hard to get it back in, unquote. Dean ignored Haldeman's advice and met with the prosecutors that afternoon. Moreover, Magruder in early April began talking with the prosecutors. His first substantive conversation with them was on April 14. Dean, according to his testimony, then began avoiding Haldeman and Ehrlichman. He did, however, have several conversations with them between April 9 and April 14, 1973. Certain of these discussions, according to Dean, involved a strategy to persuade Mitchell to, quote, step forward, unquote, and take the blame. Dean's testimony that this strategy existed is corroborated by the edited transcript of the April 14 meeting among the President, Ehrlichman, and Haldeman. This transcript basically portrays a discussion as to how to persuade Mitchell and Magruder, whom they evidently believed involved, to assume responsibility for the Watergate affair and proclaim that the White House was in no way involved. Various methods of persuasion were discussed. One was to suggest to both Mitchell and Magruder, without being specific, that clemency would be possible. The President instructed Ehrlichman to tell Mitchell and Magruder that, quote, the President holds great affection for you and your family, unquote. He added, quote, that's the way the so-called clemency's got to be handled, unquote. The April 14 conversation also indicates discussion regarding the dismissal of Dean, who was then talking to the federal prosecutors. From the conversation, it appears that the strategy to sacrifice Mitchell was motivated by the information Ehrlichman had received that Hunt was going to testify before the grand jury. Ehrlichman reported that Colson was very concerned about Hunt's possible testimony because, quote, once Hunt goes on, that's the ballgame, unquote. The President summarized Colson's advice to the White House as, quote, get busy and nail Mitchell in a hurry, unquote. The President, Ehrlichman, and Haldeman decided to appeal to Mitchell's loyalty and enlist his aid in limiting the unraveling of the cover-up. The President instructed Ehrlichman and Haldeman to approach Mitchell by saying, quote, there's nobody that can really do it except you, unquote. The President wanted Mitchell to testify that, quote, nobody in the White House is involved, etc., and so on, unquote. Subsection 8. The President's April 15 meeting with Kleindienst and Peterson. Meanwhile, U.S. Attorney Titus and Assistant U.S. Attorneys Earl Silbert, Donald Campbell, and Seymour Glanzer were outlining for Henry Peterson their discoveries in the case, which were largely based on information they were obtaining from Magruder and Dean. According to Peterson, he subsequently arranged for Kleindienst to meet with these prosecutors on the evening of April 14. An all-night session ensued, and the next day, a Sunday, Peterson and Kleindienst briefed the President on the evidence they had received, which indicated a massive cover-up. Both Peterson and Kleindienst said the President expressed no sign to them that Dean or anyone else had already imparted such information. Peterson testified he urged the President to dismiss Haldeman and Ehrlichman because of their apparent involvement in the cover-up, but not Dean, since Dean was cooperating with the prosecutors in its unraveling. Subsection 9. Further meetings between the President and Dean. On the evening of April 15, 1973, Dean said he met with the President to inform him of his discussions with the prosecutors. He testified he told the President his conduct was not, quote, an act of disloyalty, unquote, but an action he believed necessary because, quote, I felt this matter had to end, unquote. The President asked whether he had received immunity and he advised that no deal had been made. Dean stated the President instructed him not to discuss national security matters or presidential conversations with the prosecutors. He said the President then attempted to clarify his earlier March 21 comment that it would be no problem to raise $1 million in hush money. Dean said the President told him he had only been joking when he made that remark. Contrary to Peterson's advice, the President decided that Dean should leave the White House, but that Haldeman and Ehrlichman should stay. Dean testified that on April 16, the President called him into the Oval Office and gave him 2 letters prepared for his signature. Quote, one letter requested the acceptance of Dean's resignation. The other letter requested an indefinite leave of absence, unquote. Both letters cited, quote, my involvement in the Watergate matter, unquote, as cause for departure. Dean testified he refused to sign either letter. The president then, Dean said, requested Dean to prepare his own letter of resignation, which Dean agreed to do. However, late in the day, Dean said he informed the president that he would not resign unless Ehrlichman and Haldeman followed suit. The edited transcripts of these meetings confirmed Dean's testimony in large part. At the first meeting, the president told Dean he would have to say something about Dean's resignation, quote, or otherwise they will say, "What the hell? After Dean told you all of this? What did you do? You see?" unquote. The following colloquy then took place. President: But what is your feeling on that? See what I mean? Dean: Well, I think it ought to be Dean, Ehrlichman, and Haldeman. President: Well, I thought Dean at the moment. Dean: All right. President: And what I would think we would want to do is to have it in two different forms here. It seems to me that your form should be to request an immediate leave of absence. That would be one thing. The other, of course, would be a straight resignation. Dean: Uh-huh. President: First, what I would suggest is that you sign both. Dean: What I would like to do is draft up for you an alternative letter, putting in both options, and you can just put them in the file. Short and sweet. President: All right, fine. I had dictated something myself, all my own. If you can give me a better form, fine. I just want to do it either way. Do you? Or do you want to prepare something? Dean: I would like to prepare something. Later that day, Dean returned with his draft. Dean: I wrote, quote, Dear Mr. President, inasmuch as you have informed me that John Ehrlichman and Bob Haldeman have verbally tendered their requests for immediate and indefinite leave of absence from the staff, I declare I wish also to confirm my similar request as having accepted a leave of absence from the staff. Unquote. Well, I think there is a problem. President: You don't want to go if they stay. Dean: There is the problem for you of the scapegoat theory. President: You mean making use of it? Dean: That's right. Subsection 10. The question of immunity for Dean. In the evening of April 17, 1973, President Nixon told the nation, I have expressed to the appropriate authorities my view that no individual holding in the past or at present a position of major importance in the administration should be given immunity from prosecution. Dean testified that when the president issued his statement on April 17, in which he was quite obviously trying to affect any discussions I was having with the government regarding my testimony by inserting the phrase therein regarding, quote, no immunity, unquote, and combined with the fact that he had requested that I sign a virtual confession on Monday of that week, I decided that indeed I was being set up. The edited presidential transcripts provide some support for Dean's intimation that the president did not want him to receive immunity because of concern over his testimony. On the afternoon of April 17, the president expressed his concern over the threat Dean posed. President: I'm not ruling out kicking him, Dean, out, but you got to figure what the hell does Dean know? What kind of blackmail does he have? Later that afternoon, the president, observing that, quote, Dean is the only one who can sink Haldeman or Ehrlichman, unquote, informed Haldeman and Ehrlichman he had told Assistant Attorney General Peterson, quote, specifically that nobody should be granted immunity in any case, unquote. He told them, quote, I want you to go forward at all costs to beat the damn rap. They'll have one hell of a time proving it, unquote. On April 18, Peterson testified, the president called him to inquire whether Dean had been immunized. After checking with Dean's lawyer and Mr. Silbert, Peterson assured the president that Dean had not received immunity. The president told Peterson he had a tape of an April 15 conversation with Dean in which Dean said he had been immunized. The president offered to let Peterson hear the tape, but Peterson refused. On April 19, the president met with Haldeman's and Ehrlichman's lawyers, John J. Wilson and Frank Strickler. The following passage from the edited transcript of this conversation is significant. President: Then you got to remember Dean, as I have said, is a loose cannon. Wilson. I know he is. President. The damnedest charges you've ever heard. Some of them are unbelievable. Wilson. Yes. President. This fellow that was sitting in here and who in the office of the president, a very bright young guy, but he now wants to drag them down with him. Wilson. Yes, oh, he's bad. President. They must have told him what I think, have told Dean, that if he can get Haldeman and Ehrlichman, he gets immunity. Now, on that point, do you want Peterson to give him immunity or not? Wilson. President. Dean. Wilson. Well, President. Should he? Wilson. As I understood, they were hung up on that right now. President. They are. Wilson. Now. President. See, that's why I put out a statement that no major figure should be given immunity. Wilson. Let me tell you, President, basically because I think it would look bad if unintelligible from our standpoint. The edited transcripts also demonstrate that Secretary of State Rogers agreed with the president that it would look bad to give Dean immunity. On April 19, 2 days after the president's no immunity statement, Dean issued a public statement that he would not be made a, quote, scapegoat, unquote, in the Watergate affair. On the same day Dean made this statement, White House aide Stephen Bull was asked to investigate Dean's awareness of the White House taping system. In his testimony during the Watergate tapes hearings before Judge Sirica, Bull was unable to recall who instructed him to make this check. He ascertained from a White House Secret Service official that Dean did not know about the system. As former presidential assistant Alexander Butterfield testified, very few individuals were cognizant of the secret taping system. On Easter Sunday, April 22, according to Dean, the president telephoned to wish him Happy Easter. Dean characterized this as a, quote, stroking, unquote, call. Subsection 11. The President's April 30 statement. On April 30, 1973, President Nixon addressed the American public on Watergate, declaring he accepted full, quote, responsibility, unquote, for the abuses that had transpired. The President announced the resignations of Haldeman and Ehrlichman, quote, two of my closest associates in the White House, unquote, and, quote, two of the finest public servants it has been my privilege to know, unquote. He also revealed the resignations of Kleindienst and Dean, and his selection of Elliot Richardson as Kleindienst's replacement. The president stated that Dean's resignation had been requested. The president also claimed in this address that he had begun an, quote, intensive, unquote, new investigation into the Watergate matter on March 21. The background of this statement is found in the edited presidential transcript of a meeting on April 17. President. The next part is what I'm concerned about. I began new inquiries, shall we say. Ehrlichman. Well, I don't know. President. I began new inquiries into this matter as a result of serious charges, which were reported publicly and privately. Should we say that? Ehrlichman. Publicly, comma, which in some cases were reported publicly. President. 4 weeks ago why don't we say, shall we set a date? That sounds a hell of a lot stronger if we set a date. Ehrlichman. All right. President. On March 21, I began new inquiries. Strike that. I ordered an investigation. New inquiries throughout the government. On May 17, the committee opened its public hearings into the Watergate burglary and its aftermath. By August 7, 1973, when the first phase of hearings ended, the Gemstone Plan, the break-in, the details of the cover-up, and much more had been revealed. End of Section 9. Section 10 of the Watergate Report, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by John Dennison, Portland, Maine. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 1, Section 10. Section 3, Recommendations. Recommendation 1. The committee recommends that Congress enact legislation to establish a permanent Office of Public Attorney, which would have jurisdiction to prosecute criminal cases in which there is a real or apparent conflict of interest within the executive branch. The public attorney would also have jurisdiction to inquire into, with power to gain access to executive records, the status and progress of complaints and criminal charges concerning matters pending in or involving the conduct of federal departments and regulatory agencies. The public attorney would be appointed for a fixed term, e.g., 5 years, be subject to Senate confirmation, and be chosen by members of the judicial branch to ensure his independence from executive control or influence. In each of the nation's 2 major scandals during the past half-century, Teapot Dome and Watergate, the appointment of a special prosecutor was essential to preserve the integrity of the criminal justice system and public confidence in the rule of law. In both situations, the office was created after serious abuses had occurred. The evidence gathered by the Select Committee indicates that unmonitored executive, investigative, and prosecutorial agencies may be reluctant to expose wrongdoing in the executive branch. It is thus essential that an independent public attorney's office be created to investigate and prosecute where conflicts of interest in the executive branch exist. This office should be given power to inquire fully into corruption in the executive branch and have access to all records relating to such corruption. The operations of the current Special Prosecution Force demonstrate the effective role such an entity can play. The preventative role this office could fulfill must be emphasized. Permanent status for this office could help ensure responsible action by executive branch officials who have primary responsibility to administer and enforce the law. Indeed, it is reasonable to speculate that the existence of a public attorney's office might have served as a deterrent against some of the wrongful acts that comprise the Watergate scandal. Because of this preventative role, it is unwise to wait until another national crisis to reinstitute the Office of Special Prosecutor. It is far better to create a permanent institution now than to consider its wisdom at some future time when emotions may be high and unknown political factors at play. The public attorney we recommend would not be only a, quote, special prosecutor, unquote, but an ombudsman having power to inquire into the administration of justice in the executive branch. With a power of access to executive records, he could appropriately respond to complaints from the public, the Congress, the courts, and other public and private institutions. If he became aware of misconduct in the executive branch, he could assume the role of special prosecutor. The public attorney should also be required to make periodic reports to Congress on the affairs of his office and the need for new legislation within his jurisdiction, a function that should be of great assistance to the relevant congressional oversight committees. The Attorney General should find such an office advantageous in cases involving charges against administration officials or persons otherwise close to high executive officers, particularly where a proper exercise of discretion not to prosecute would give rise to public suspicion of cover-up. Such cases could be referred by the Attorney General to the public attorney. The public attorney would also have jurisdiction to prosecute all criminal cases referred to it by the Federal Elections Commission, which is elsewhere recommended in this report. It is not anticipated that there would be substantial jurisdictional disputes between the Justice Department and the public attorney. The statute establishing the public attorney should grant him discretionary jurisdiction in any situation where there is a reasonable basis to conclude that a conflict of interest exists. He should have exclusive jurisdiction over criminal cases referred to him by the Federal Elections Commission. As to cases where a jurisdictional dispute cannot be resolved, provision should be made for special judicial determination on an expedited basis. Deciding such jurisdictional disputes would be well within the competence of the courts, for the question would primarily be one of statutory interpretation. The present immunity statute would have to be amended to allow the independent prosecutor to grant "use" immunity without the consent of the Attorney General. The procedure by which the public attorney obtains immunity should be made similar to that applicable to congressional requests for immunity. The Attorney General would be informed of an immunity request, but he could only delay the immunity, not prevent it. Similarly, the Attorney General would inform the public attorney of his immunity decisions. The public attorney would have the power to delay, not prevent, immunity. To guarantee true independence from the executive branch, the public attorney should be appointed for a fixed term, e.g., 5 years. He should be removable only by the appointing authority, described below, for gross improprieties. Because it is highly important that the special prosecutor act solely in the interest of justice and not for personal benefit, he should be ineligible for appointment or election to federal office for a period of 2 years after his term expires, or he resigns or is removed. Crucial to the independence of the public attorney is the appointing authority. If the appointing authority is vested in the President or the Attorney General, who is responsible to the President, the appearance of political influence would remain even if the public attorney has an extended tenure. The argument in favor of presidential appointment is that criminal prosecution is an executive function, and there is a presumption of regularity respecting the exercise of presidential power that should not be disregarded because of the unique abuses of Watergate. But Watergate at least teaches that the abuse of power must be anticipated. The committee's recommendation that responsibility for appointment of the public attorney should rest with the judicial rather than with the executive would establish a check against future abuse of power. The Constitution allows the vesting of the appointment power in others besides the chief executive. Article 2, Section 2, Paragraph 2, Clause 2 provides, "The Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments." The few cases interpreting this clause support a plan by which the public attorney is appointed by the courts of law. The leading case is Ex parte Siebold 100 U.S. 371, 1879. Congress, pursuant to the Enforcement Acts of 1870 and 1871, vested the appointment of election supervisors in the circuit courts. The Supreme Court upheld the constitutionality of this appointment power, observing that there could be other appointments which Congress might want a court to make, such as a marshal. Quote, "The marshal is preeminently the officer of the courts." Unquote. Apparently, the only limitation on the court's appointment power is that the office involved must not be of, quote, "such incongruity to the judicial function as to excuse the courts from performance of the appointing function or to render their acts void." Unquote. Since a prosecutor is more an officer of the court than a marshal or election supervisor, it is difficult to contend that the appointment of a public attorney is, quote, "incongruous," unquote, to the judicial function. The District Court for the District of Columbia relied heavily on Ex parte Siebold in upholding the constitutionality of a provision of the D.C. Code which required the members of the Board of Education to be appointed by the judges of that court. Hobson v. Hansen, 265 F. Sup. 902, DDC 1967, the court read the congruity requirement of Ex parte Siebold narrowly. The limitation which is referred to in Siebold is not an affirmative requirement that the duty of the officer be related to the administration of justice. It is a negative requirement that the duty may not have, quote, "such incongruity," unquote, with the judicial function as would void the power sought to be conferred. In short, given the clear congruity between the public attorney's tasks and the judicial function, it should be constitutional for the Congress to vest the appointment power in the judicial branch. See also Rice v. Ames, 180 U.S. 371, 1901. Congress has power to authorize circuit courts to appoint commissioners to handle extradition matters. Russell v. Thomas, 21 Fed Cases 12, 162, 1874. Congress has power to authorize courts to appoint U.S. commissioners of insolvency. Birch v. Steele, 165 F. 577, Fifth Circuit, 1908. Congress has power to authorize courts to appoint referees in bankruptcy. While it is thus constitutional to vest the appointment of a public attorney in the judicial branch, the question remains as to what part of the judicial branch should have this power. It would be a safer constitutional scheme if the appointing authority were in no way involved in hearing the cases to be prosecuted by the public attorney. If a district judge, for example, was directly responsible for appointing a public attorney to prosecute certain individuals before that same district judge, questions respecting an appearance of partiality and the lack of due process might be raised. In Hobson v. Hansen, 265 F. Sup. 902, DDC 1967, the court recognized possible due process problems but stated that the official act of participating in the selection of board members does not in and of itself preclude on due process grounds the ability of the judge to decide fairly the merits of litigation challenging the validity of the performance by a board member of his duties as such. If in a particular case such a challenge were made, its soundness on due process grounds would depend on the circumstances bearing thereon, and not on the mere fact that the judge had performed the duty reposed upon him by Congress in Section 31 to 101, 265 F. Sup. 918. The possible problems raised in Hobson were also discussed in United States v. Solomon, 216 F. Sup. 835, SDNY 1963. The Solomon Court upheld the validity of 28 U.S.C. Section 506, now 28 U.S.C. Section 546, which permitted the district court to appoint a U.S. attorney when a vacancy occurs to serve until that vacancy is filled by the president. But the court emphasized that the judicial appointment was temporary in holding that the, quote, statutory scheme for the temporary appointment by the judiciary of the U.S. attorney comports in all respects with due process of law, unquote. The court was apparently concerned that if it also had the power to remove the prosecutor it appointed, there might be a, quote, nexus between court and prosecutor too close to comport with due process, unquote. Although the concerns expressed in Solomon were dictum, it would be the wiser course to avoid an appointment procedure that would involve active judges who might hear cases brought by a prosecutor they appointed and could remove. To avoid these constitutional problems and to create an office of public attorney that is not only truly independent, but also appears truly independent, the Congress should vest the appointment power as follows. The Chief Justice should be given the power and duty to select 3 retired circuit court judges who, in turn, would appoint the public attorney. After the Chief Justice makes the initial appointment of the 3 circuit court judges, his responsibilities would be ended. The 3 retired circuit court judges, who would not sit on any cases, either at trial or in an appellate capacity, in which the public attorney's office was involved, would make the actual appointment, which would be subject to confirmation by the Senate. The public attorney could be removed only by the 3 retired circuit court judges and only upon a finding of gross improprieties. At the end of the 5-year period, the Chief Justice would appoint or reappoint 3 retired circuit court judges and they, in turn, would choose a new public attorney, or reappoint the outgoing public attorney for 1 additional term only. Although Canon 5 of the Code of Judicial Conduct discourages extrajudicial assignments in controversial matters, it does permit assignments dealing with the administration of justice. Thus, the acceptance of an appointment by a senior judge to a public attorney supervisory committee would be permissible under the canons. A senior judge accepting the appointment would not receive any additional salary because of such service. Recommendation 2. The committee recommends that, in connection with its revision of the Federal Criminal Code, Congress should treat as a separate federal offense with separate penalties any felony defined in the code, except those felonies that specifically relate to federal elections, that is committed with the purpose of interfering with or affecting the outcome of a federal election or nominating process. The purpose of this proposal is primarily to establish, as a separate federal crime, the commission of certain traditionally common law offenses such as burglary and larceny, where these crimes are committed with the intent of interfering with or affecting a federal election or nominating process. To understand this proposal, it is necessary to comprehend the workings of the three main proposed revisions of the Criminal Code now before Congress: H.R. 10047, the Brown Commission proposal; S. 1400, the Administration's proposal; and S.1, the proposal of the staff of the Criminal Procedure Subcommittee of the Senate Judiciary Committee. Each of these proposals would make certain traditional common law offenses, usually prosecutable only in the state courts, federal offenses in certain circumstances, for example, if the victim is a federal public servant or if the property that is the subject of the offense is federally owned. Each proposal defines the various common law crimes that will become federal crimes triable in federal courts in the proper circumstances. In each case, the list is lengthy. As noted, the proposal the committee offers is to make various common law crimes federal offenses prosecutable in federal courts when the offenses are conducted with the intent to interfere with or affect a federal election. It would thus add another jurisdictional base for the federal courts to those already suggested by the existing revisions, for example, that the crime is against a federal employee. The proposal also establishes a separate offense all other violations of federal criminal law, except those laws that specifically relate to federal elections, where the offense is committed with intent to interfere with or affect a federal election or nominating process. The committee feels that the amendment it proposes is needed. Under existing law, the DNC burglary and the break-in of Dr. Fielding's office could not be tried in a U.S. District Court under a burglary indictment. The defendants in the Fielding break-in matter were prosecuted on conspiracy and perjury counts. Adoption of the above proposal would not add redundancy to the criminal law. Rather, it would allow the prosecution of crimes in which there is a federal interest in federal courts, and it would allow the prosecutor to present an election-related offense to the jury in proper perspective, that is, as an attempt to violate the integrity of a federal election or nominating process. Such a statute would carry appropriate penalties to indicate the gravity of corrupt interference with the federal electoral process. For example, a fine up to $25,000 and/or imprisonment up to 5 years. Recommendation 3. The committee recommends that Congress enact legislation making it unlawful for any employee in the executive office of the President or assigned to the White House directly or indirectly to authorize or engage in any investigative or intelligence gathering activity concerning national or domestic security not authorized by Congress. The evidence received concerning the establishment, by direction of the President, of a special investigative unit in the White House, the Plumbers, and the operations of the Plumbers illustrates the danger to individual rights presented by such secret investigative activity. By statute, Congress has already established various professional investigative agencies to serve the executive's legitimate investigative needs. For example, the CIA, the FBI, the Secret Service. These bodies are wisely restricted in their jurisdiction and authority by stringent statutory provisions and are answerable not only to the executive but also to special oversight committees of Congress. Thus, our free society is served, not controlled, by its police agencies. No president should be allowed to circumvent these agencies and erect a secret White House investigative operation, such as the plumbers, not subject to statutory controls and congressional oversight. If any agency charged with investigative efforts is deficient, the president should reform it, not create a substitute. Under the proposed recommendation, it would be a criminal offense for anyone in the White House or the executive office of the president to perform investigative or police functions relating to internal or national security matters, unless existing statutory law already authorizes such functions, as with the Secret Service. Similarly, it would be illegal for anyone in the executive office of the president or on the White House staff to employ any person to conduct such functions. Recommendation 4. The committee recommends that the appropriate congressional oversight committees should more closely supervise the operations of the intelligence and law enforcement "community." In particular, these committees should continually examine the relations between federal law enforcement and intelligence agencies and the White House, and promptly determine if any revision of law is necessary relating to the jurisdiction or activities of these agencies. From its beginning, the Central Intelligence Agency has been prohibited from performing police and internal security functions within the United States. Thus, 50 U.S.C. Section 403 D3 explicitly provides that the agency shall have no police, subpoena, law enforcement powers, or internal security functions. Notwithstanding this clear and longstanding prohibition, the Select Committee produced evidence that the White House sought and achieved CIA aid for the plumbers and unsuccessfully sought to involve the CIA in the Watergate cover-up. These efforts on the part of the White House underline the need for constant and vigorous congressional oversight. The congressional committees charged with the responsibility for the CIA should thus consider the need for hearings to determine if more explicit statutory language would be useful to restrain the CIA to its legitimate sphere of operation. As for law enforcement agencies, testimony of the former acting director of the Federal Bureau of Investigation, Patrick Gray, and others regarding White House attempts to interfere with the FBI's investigation of the Watergate affair, as well as evidence received by the committee as to efforts by the White House to influence IRS operations, indicate that similar oversight functions should be strengthened with regard to the FBI, IRS, and other similar agencies. Recommendation 5. The committee recommends that Congress amend 1. The false declaration prohibition of 18 U.S.C. Section 1623 to make it equally applicable to congressional proceedings under oath. 2. Section 1621 of Title 18 to provide that once the oath has been properly administered by a congressman in a public or private congressional hearing, it is not a defense to a perjury charge that subsequently a quorum was absent or no congressman was present when the perjurious statement was made. 1. The false declaration prohibition of 18 U.S.C. Section 1623C in effect provides that to sustain a perjury conviction regarding statements made under oath to a court or grand jury or in a civil deposition, the government must only show that two statements made under oath in any of these forums are inconsistent. This provision should be made equally applicable to congressional proceedings under oath. There is no policy justification for granting proceedings in other forums a greater protection from perjury than given congressional investigations. 2. Under Section 1621 of Title 18, as interpreted by the courts, it appears that conviction for perjury before a congressional body will not lie in the absence of a quorum when the offending statement was made. See Christoffel v. United States 338 U.S. 84, 1949, which concerned a House subcommittee and the analogous District of Columbia perjury statute, D.C. Code Section 22 to 2501. The Select Committee has found it necessary to conduct numerous executive sessions under oath where a senator was not present for the entire hearing. To require a senator or congressman to be present at all times during executive sessions stifles vigorous, far-reaching investigations because there is simply not enough congressional time available. Section 1621 of Title 18 should thus be amended to provide that in regard to a perjury charge relating to congressional testimony under oath, it is not a defense that there was no quorum or no congressman present when the perjurious statement was made. When a witness has been placed under oath, he is on fair notice that his testimony must be truthful. A civil litigant can depose a witness under penalty of perjury without a judge present, and the law should not require that, in order to sustain a perjury charge regarding congressional testimony, a congressman be present. The fact that a congressman is required to place a witness under oath should provide ample protection against possible harassment by staff investigators. See 2 U.S.C. Section 191, Oath to Witnesses. The present recommendation is not intended to require a witness to answer questions when a quorum of the congressional committee is not present. It relates only to a witness who has been sworn when a quorum is present and who chooses to respond to questions in the absence of a quorum. Recommendation 6. The committee recommends that the Congress refrain from adopting proposed revisions of Title 18, which would unjustifiably broaden the present defenses to criminal charges of official mistake of law and execution of public duty. The committee supports the predominant rule of law adopted in the American Law Institute's Model Penal Code that any reliance on a mistake of law or superior orders must be objectively reasonable to constitute a valid defense. There are several proposals before the Congress. H.R. 10047, Sections 521 and 532, and S1, Sections 303 and 1 to 306b, which would expand the present common law defense of official mistake of law and execution of public duty. Under existing law, a public official who can show that conduct taken in the course of his duties resulted from an objectively reasonable mistake of law or reliance upon superior orders has a valid defense to a criminal charge relating to that conduct. See Perkins on Criminal Law 2 ed. 1969, pages 921 to 2. The proposed drafts would apparently erect as a defense to a criminal charge a subjective, good faith reliance by a public official on an official grant of permission or interpretation of the law. Under the proposals, it appears that the defense would still lie even if the official grant of permission or interpretation of the law were oral and secret. These proposed revisions were drafted before the Select Committee's hearings, which presented substantial relevant evidence bearing on this issue. The Select Committee rejects the broadening of this defense incorporated in the proposals now before Congress. The committee recognizes that the proposed revisions are based on extensive studies of the present criminal law that range far beyond the scope of the committee's own investigation. However, based on its experience, the committee believes that the present law, as reflected in the American Law Institute's Model Penal Code, is adequate to meet all legitimate claims of official mistake of law or public duty and should not be expanded. Recommendation 7. The committee recommends that the appropriate committees of Congress study and reconsider Title III of the Omnibus Crime and Safe Streets Act of 1968 for the purpose of determining whether the electronic surveillance provisions contained in that act require revision or amendment. The committee's investigation has revealed incidents of unlawful violations of privacy through electronic surveillance, some of which were committed directly or indirectly under the auspices of the entities of government in whose trust Congress placed the protection of privacy by the provisions of Title III of the Safe Streets Act of 1968. The restrictions contained in that act have proved inadequate to protect individuals against unjustified invasions of privacy. A thorough reevaluation of this legislation, including a factual investigation of federal wiretapping practices, is necessary. Under the 1968 Act, a special commission was to be appointed by the President 5 years after the effective date of the Act. The President has now appointed this commission for the purpose of evaluating the strengths and deficiencies of this legislation. However, the committee believes that in light of the facts revealed in its investigation of a scandal in the executive branch unforeseen by Congress when it enacted the 1968 Act, it is essential that the appropriate committees of Congress make their own investigations and evaluations of the experience under the new federal electronic eavesdropping law. It appears to be inappropriate to rely solely on a presidential commission, which must report to the same administration under which violations of privacy took place. An important issue for consideration is whether national security electronic surveillance should require prior court approval. Both the Supreme Court and the Congress have left this matter unresolved. In United States v. U.S. District Court 407 U.S. 297, 1972, the court firmly rejected the government's claim that warrantless electronic searches in domestic security cases were a reasonable exercise of presidential power. Justice Lewis Powell's opinion for a unanimous Supreme Court concluded that, quote, prior judicial approval is required, unquote, for domestic security surveillance. The issue arose in a case in which the Attorney General had authorized wiretaps, quote, to gather intelligence information deemed necessary to protect the nation from attempts of domestic organizations to attack and subvert the existing structure of the government, unquote. The court said that although the Fourth Amendment's requirement of a warrant before a search is not absolute, the prior judgment of an independent magistrate is the norm. Quote, Fourth Amendment freedoms cannot be properly guaranteed if domestic security surveillances may be conducted solely within the discretion of the executive branch, unquote. Although Justice Powell carefully limited his opinion to, quote, the domestic aspects of national security, unquote, and expressed no opinion on, quote, the issues which may be involved with respect to activities of foreign powers or their agents, unquote. He did state, quote, nor do we believe prior judicial approval will fracture the secrecy essential to official intelligence gathering. Judges may be counted upon to be especially conscious of security requirements in national security cases, unquote. But see Laird v. Tatum, 408 U.S. 1, 1972, in which the Supreme Court, 5-4, failed to find a justiciable controversy so as to permit a decision on the merits of the Army's surveillance of civilian political activity. In view of the fact that the court has left unanswered the question whether warrants are necessary with respect to intelligence regarding foreign activities, it is clear that Congress should address itself to the question whether prior judicial approval should be required for all wiretaps and other electronic surveillance. The Select Committee so recommends. In the wiretap case just discussed, Justice Powell suggested that, quote, Congress may wish to consider protective standards for foreign intelligence wiretaps, which differ from those already prescribed for specified crimes in Title III of the 1968 Crime Control Act. Different standards may be compatible with the Fourth Amendment if they are reasonable both in relation to the legitimate need of government for intelligence information and the protected rights of our citizens, unquote. While the Supreme Court has not ruled on the validity of warrantless wiretaps not involving U.S. citizens to achieve foreign intelligence, at least 2 courts of appeals have held that such surveillance does not violate the Fourth Amendment. See United States v. Brown, 484, F. 2D 418, Fifth Circuit, 1973, and United States v. Dellinger, 472, F. 2D 340, Seventh Circuit, 1972. There is no justification totally to prohibit the executive from conducting such surveillance, but when it is done within the United States, it is preferable that a warrant be obtained prior to the wiretap. Congress should take cognizance of Justice Powell's invitation to the wiretap case and address itself to this issue. Suitable legislation should establish procedures permitting the courts under designated standards to authorize surveillance of foreign powers. A basic standard that could be employed is whether there is reason to believe that information of importance to the nation's security would be obtained. To obviate possible disclosure of such activities, Congress could establish special procedures to be followed. This could be done easily and effectively by a provision that all such warrants be issued by a single judge, perhaps the Chief Judge of the U.S. District Court for the District of Columbia. Staff work could be performed by the Department of Justice so that only the judge himself need see the warrant and supporting material. And special procedures should be established to protect the rights of American citizens who might be overheard. In net, the need is for prior judicial approval under guidelines that will protect national security. There should be no constitutional barrier to such legislation. As Justice White said in his concurring opinion in the wiretap case, quote, "The United States does not claim that Congress is powerless to require warrants for surveillance which the President otherwise would not be barred by the Fourth Amendment from undertaking without a warrant," unquote. In fact, the wiretap case is a direct holding by the Supreme Court that Congress can limit the executive's power to tap without a warrant. In a footnote to Justice White's opinion, he indicated that the Justice Department, speaking through Assistant Attorney General Robert Martian, accepted the view that Congress does have such power. End of Section 10.
Section 11 of the Watergate Report, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Warren Cotty, Gurnee, Illinois. Final Report of the Senate's Select Committee on Presidential Campaign Activities, Volume 1, Section 11. Chapter 2, Campaign Practices. Introduction. The campaign to re-elect President Nixon in 1972 was expensive, intense, and long. It began in late March 1969, soon after the president's inauguration, when John Ehrlichman, counsel to the president, hired Jack Caulfield to gather political intelligence and derogatory information on individuals considered to be unfriendly to the new administration. Caulfield and Ehrlichman interviewed a former New York City policeman, Anthony T. Ulasewicz, in late May 1969 and hired him to conduct investigations. Ulasewicz was paid secretly by Herbert Kalmbach, the president's personal attorney, from an unused reserve of 1968 Nixon campaign funds. The establishment of an offensive intelligence gathering capability in the White House occurred, then, before many members of the administration had even moved into their Washington offices. Other intelligence gathering capabilities later initiated included the Plumbers, the efforts of Colson and Hunt, the activities of Donald Segretti and others, and the Gemstone Conspiracy. In the Caulfield-Ulasewicz operation, as in several other examples of campaign practices investigated by the Select Committee, serious questions are raised as to what the president knew, approved, or condoned, and what his ethical and legal responsibility should be for the campaign conduct of his subordinates. This report focuses on the presidential campaign practices that raise substantial questions of legality, propriety, or ethics, and that may, in the words of S. Resolution 60, quote, indicate the necessity or desirability of new congressional legislation to safeguard the electoral process by which the President of the United States is chosen, unquote. Section 1A. The report is not an exhaustive compendium of every campaign practice investigated by the Select Committee. Rather, it is a selection of those incidents that raise particularly serious questions of campaign propriety and ethics that, consequently, frame most clearly questions about the advantages and disadvantages of remedial legislation. Running through the various topics raised below are several themes that merit serious discussion by Congress, for they raise fundamental questions about how our system of free elections should be run. First, the 1972 presidential campaign was replete with abuses of positions, power, and prerogatives, particularly by White House personnel. The political advantages held by an incumbent president are immense, and they were constantly used and abused by this administration. A corollary to the abuse of presidential incumbency for political gain is the considerable extent to which objectionable campaign practices were conceived, encouraged, and controlled by high-level presidential aides. This was true from the early days of the first term, when there was no campaign organization, and it continued to be so through the 1972 election. Another important theme is the misuse of large amounts of money, especially difficult to trace cash that was held in secret places in the White House and elsewhere. The problem with cash in political campaigns is not, of course, unique to the campaign practices facet of the Select Committee's investigation. Cash contributions and funds played key roles in virtually all aspects of the 1972 presidential election. The misuse of cash in various campaign practices, as in other areas, demonstrates the need for strict regulation of its use in political campaigns. Another recurring theme was the search for intelligence information on political opponents, which was initiated with the hiring of Caulfield and Ulasewicz. This intelligence gathering is central to the first part of this report. White House-inspired political activities 1968 through 1971. In addition to Caulfield and Ulasewicz, this part summarizes the campaign activities of E. Howard Hunt, the Plumbers, and the various improper uses and attempted uses of federal agencies by White House staff members. For example, evidence shows that the White House attempted to use the Internal Revenue Service to harass persons perceived as political enemies. In addition, some of the public relations efforts which were initiated in the White House led to practices which were deceptive and misleading to the public. The White House also attempted to mislead and deceive the press on numerous occasions. While legislation in this area is inadvisable, examples of White House attempts to mislead the press were quite frequent during the last month of the 1972 campaign, and helped to explain the attitude within the White House and some of the tactics employed to re-elect Mr. Nixon. With the above areas as background, the second half of the report outlines what happened in the campaign itself, beginning with the strategy of the campaign to re-elect President Nixon. A basic theme of the strategy was to attack Democratic opponents and prospective opponents frequently during the primaries. Such an attack strategy was a key ingredient in the 1972 Nixon campaign. Although many people contributed to this strategy, its broad outlines were best explained by White House speechwriter Patrick Buchanan, whose memorandums are summarized below in this report. The strategy, though not improper in itself, was ultimately converted by others into gross abuses and unethical manipulations of the electoral process by persons who had little political experience and by persons, including some with considerable political experience, who had little respect for fair play in elections. The activities of Segretti and others, and of their superiors in the White House and at the Committee to Re-elect the President, are detailed below in this report. Their activities consisted primarily of surreptitious information gathering and disruption of Democratic campaigns. Finally, the report discusses allegations of unfair campaign practices directed at President Nixon's campaign. The staff did uncover some instances of improper activity directed at President Nixon's re-election campaign. The results of these investigations, however, show no pattern of illegal, improper, or unethical activities carried out or condoned by any Democratic aspirant or Democratic campaign organization. 1. White House-inspired political activities, 1968 through 1971. Part A. Caulfield and Ulasewicz. From the time Richard Nixon was inaugurated president in January 1969, the White House exhibited a strong desire for political intelligence that helped lead to the events in the campaign of 1972, which have been under investigation by the Select Committee. Shortly after President Nixon entered the White House on January 21, 1969, the decision was made in the White House to establish an in-house investigative capability that could be used by the president's staff for obtaining sensitive political information. Jack Caulfield was chosen to perform this function. Following a career in the New York City Police Department, Caulfield was hired in May 1968 by H.R. Haldeman to, quote, serve in the security area, unquote, during the 1968 campaign. Caulfield was responsible for securing staff quarters and working areas of the Nixon traveling campaign in 1968. Following the election, Caulfield was interviewed and subsequently turned down by John Mitchell for the position of Chief U.S. Marshal. Subsequently, in late March 1969, Caulfield met with John Ehrlichman at his White House office, and Ehrlichman asked if Caulfield were interested in setting up a private security entity in Washington, D.C., to provide investigative support for the White House. The next day, Caulfield called Ehrlichman with a counterproposal that he join the White House staff under Ehrlichman and, quote, besides providing liaison functions with the various law enforcement agencies, thereby be available to process any investigative request from the White House, unquote. Ehrlichman agreed, and Caulfield was placed on the White House payroll. Caulfield told Ehrlichman that he intended to use the services of Anthony Ulasewicz, a detective with the New York City Police Department who was nearing retirement. Ehrlichman wanted to meet Ulasewicz, and so in May 1969, Ulasewicz was interviewed by Ehrlichman and Caulfield in the VIP lounge at the American Airlines terminal of New York's LaGuardia Airport. Ehrlichman explained to Ulasewicz that he wanted discreet investigations done on certain political figures. During their brief conversation, Ehrlichman agreed to a one-year contract for Ulasewicz at $22,000 per year plus expenses, and Ulasewicz explained that he wanted to report to only one individual and to make no written reports of any kind. Following the meeting, Ehrlichman told Herbert Kalmbach, the president's personal attorney, to make arrangements to put Ulasewicz on the payroll. Ulasewicz was paid with surplus funds from the 1968 campaign, which were held in trustee accounts by Kalmbach. At 8 a.m. Sunday, June 29, 1969, Herbert Kalmbach met Jack Caulfield and Tony Ulasewicz at the Madison Hotel in Washington, D.C. Ulasewicz told Kalmbach he would use the alias Edward T. Stanley in his work, and Kalmbach agreed to send salary and expense checks to Ulasewicz's home twice a month. Samples of checks used to pay Ulasewicz are attached to this report. During the next 3 years, Kalmbach paid more than $130,000 for the Caulfield-Ulasewicz operation. Ulasewicz's complete travel records are available in the files of the committee, and a summary chronology of Ulasewicz's travels is appended to this report. Ulasewicz received all investigative assignments from Caulfield orally, whom he contacted discreetly by calling under the pseudonym of Mr. Stanley, so that no one at the White House would know his true identity. On July 8, 1969, Ulasewicz spoke with Kalmbach by telephone and agreed to use his own American Express card for air travel and other necessary expenses. Kalmbach directed Ulasewicz to apply for a second American Express card in the name of Edward T. Stanley, and Kalmbach agreed to guarantee payment on that account. Kalmbach also agreed to obtain telephone credit cards for Ulasewicz in his real name and in the name of Edward T. Stanley, thus allowing Ulasewicz to maintain his secrecy during the course of his upcoming investigations and inquiries. At about 1 a.m. on Saturday, June 19, 1969, Senator Edward Kennedy was involved in an automobile accident at Chappaquiddick, Massachusetts. Later that morning, as news reports of the accident reached the public, Caulfield was directed by Ehrlichman to send Ulasewicz to the scene of the accident as soon as possible. Ulasewicz flew to Boston on the Eastern Airlines shuttle on July 19 and rented a car for the trip to Martha's Vineyard and Chappaquiddick. Ulasewicz spent 4 days in the area on this first visit and reported back continually to Jack Caulfield in the White House, who passed the information on to Ehrlichman and others as it developed. Ulasewicz spent a good portion of the remaining summer and much of the fall of 1969 at Chappaquiddick, trying to dig up politically valuable information from Senator Kennedy's accident. Caulfield also gave Ulasewicz a variety of other assignments after the summer of 1969. During the next 3 years, Ulasewicz traveled to 23 states, gathering information on assignments from Caulfield. In 1969 and 1970, Caulfield stated that he got his directions from Ehrlichman and sometimes from other high-ranking White House officials, such as H.R. Haldeman, Lynn Nofziger, and occasionally Charles Colson. While Ulasewicz's investigations covered a variety of political opponents of the administration and potential threats to the president's re-elections in 1972, much of his attention focused on Senator Kennedy, Senator Muskie, Larry O'Brien, and columnist Jack Anderson. A list of the investigations and background checks conducted by Anthony Ulasewicz at the direction of Jack Caulfield is attached to this report. After Senator Muskie became the leading Democratic contender immediately following the 1970 congressional elections, many of Ulasewicz's investigations were directed toward discovering valuable political information on Senator Muskie. Ulasewicz usually worked alone on the assignments he was given by Caulfield. However, in December 1971, Anthony LaRocco, a former New York City police detective, was hired to assist Ulasewicz. LaRocco assisted Ulasewicz in 4 or 5 investigations in New York City from December 1971 until the 3rd week in January 1972, when Ulasewicz informed LaRocco that the operation was terminated. LaRocco received a total of about $1,500 for his work on behalf of the White House. 1. Electronic surveillance. There has been no evidence presented to the Senate Select Committee which indicates that either Ulasewicz or LaRocco engaged in any electronic surveillance in their assignments for the White House. However, Jack Caulfield was involved twice in the implementation and monitoring of electronic surveillance. The first occasion was in June 1969, when Ehrlichman called Caulfield into his office and said that there was an urgent need for a national security wiretap on the telephone of columnist Joseph Kraft. Caulfield said that Ehrlichman told him that he did not want to go through the FBI, since it was a sieve. Ehrlichman pressed Caulfield to place the tap on as soon as possible. Ehrlichman testified that he was sure that he discussed that tap with President Nixon. Caulfield contacted Jack Reagan, a former FBI agent and friend from the 1968 campaign for whom Caulfield had found a job at the Republican National Committee in 1969. Caulfield told Reagan he had a directive from Ehrlichman to place a wiretap on Kraft's phone because of a matter involving, quote, high-priority national security, unquote. Reagan and Caulfield drove to Kraft's residence and concluded from observation of the neighborhood and the location of the telephone lines that it could be a very difficult tap to install. Caulfield went back to Ehrlichman and explained the serious problems they would encounter in attempting to install the tap. Caulfield testified that Ehrlichman told him that the tap had to be installed. Reagan told Caulfield he could not implement the wiretap unless he had the pairs and cable numbers of the telephone lines in the Kraft home. Caulfield agreed to obtain the information and did so by requesting it from a friend of his in the Secret Service. Caulfield explained to the individual in the Secret Service that he needed the information as a matter of national security. The information was obtained for Caulfield, who in turn gave it to Reagan. Reagan also asked Caulfield about acquiring appropriate credentials from the telephone company to protect himself while implementing the wiretap and to ensure the discretion of the assignment. Caulfield discussed the problem with Ehrlichman, who arranged for Caulfield to speak with John Davies of the White House staff. Caulfield told Davies he needed a telephone installer's card for a job concerning a, quote, national security matter, unquote, he had been given by Ehrlichman. Caulfield had the impression that Ehrlichman and Davies had already talked about the matter. Davies did provide a telephone installer's card to Caulfield, who in turn passed the card on to Reagan. About 1 week or 10 days after he made his initial request to Caulfield to implement the wiretap, Ehrlichman called Caulfield and directed him to desist from implementing the wiretap because J. Edgar Hoover would take care of it. Ehrlichman testified that the wiretap in 1969, quote, never happened, unquote. Caulfield then called Reagan to direct him not to implement the tap, but Reagan told him, quote, it's done, unquote. Caulfield testified that Reagan and an unidentified friend of his from New York had already come to Washington and installed a listening device on a telephone pole in the rear of Kraft's residence. Caulfield met with Reagan at the Congressional Hotel and told him he had been directed by Ehrlichman not to place the wiretap. Reagan explained to Caulfield how he and his friend had placed the tap and gave Caulfield a tape, which allegedly contained some conversation from Kraft's telephone. Reagan told Caulfield that Kraft's voice was not on the tape, and that the overheard conversation may have involved a maid. Caulfield testified that he took the tape from Reagan to his office, where he ran out about 40 or 50 feet of it and destroyed it by placing it in his burn bag. Caulfield kept the remaining tape in his office for about a month or two and then destroyed it and the reel itself by placing them in the burn bag in the White House. Caulfield claimed that neither he nor Ehrlichman nor anyone else ever listened to the tape that Reagan gave him. Reagan was paid no money for his work in placing the wiretap. Reagan, Ulasewicz, and Caulfield continued to be social friends after this incident in 1969, lunching together on numerous occasions when Reagan came to Washington. During 1969 and 1970, Reagan gave approximately 8 checks to Caulfield totaling about $800. While Caulfield had no recollection of the purpose of these payments, Reagan said they were to obtain information from police departments. Finally, there is no evidence at the present which indicates that Caulfield had Reagan conduct any other electronic surveillance. Reagan did, on occasion, ask Ulasewicz if he were interested in performing jobs for Reagan, but no actual work assignments developed from these suggestions. The second occasion when Caulfield was involved in electronic surveillance came in the fall of 1970, when Ehrlichman requested Caulfield to monitor the results of the Secret Service wiretap of F. Donald Nixon. Caulfield monitored the tap for about 3 weeks before the project was terminated. Ehrlichman refused to discuss the wiretap with the Select Committee, citing national security privilege. The Secret Service, at the direction of the White House counsel, would not allow agents involved to testify about the matter, claiming that it fell within the, quote, protective function, unquote, of the Secret Service and therefore was privileged. 2. Operation Sandwedge. In late 1970 and early 1971, Jack Caulfield began thinking about establishing a private security organization when he left the White House. In the winter and early spring of 1971, Caulfield recalled having frequent discussions about the idea with Miles Ambrose, then Commissioner of Customs. Ambrose had discussed the idea of private security business with Mike Acree, then Assistant Commissioner of the IRS. Sometime in late 1970 or early 1971, Ambrose introduced Acree to Caulfield. Caulfield told Acree that Ambrose and Caulfield were planning to open a private security firm in Washington, D.C. Acree had friends at Intertel, a private security firm in Washington, and thought that such a business might be a good means of retiring from federal service. Acri had said that at no time in these early discussions did Caulfield mention anything about a, quote, covert operation, unquote. Caulfield told Acri that Ambrose wanted to head the new organization, but that Caulfield was slowly trying to move him out of the picture. Sometime in the spring of 1971, Caulfield told John Dean he was thinking about leaving the White House staff to establish an investigative and security consulting corporation. Caulfield explained to Dean that the proposed firm could be operational by campaign time and could provide important help to the re-election campaign and to the Republican National Committee. Caulfield's basic idea was that the security firm would provide services for large corporations and that, with large fees from them, it would be able to provide free services to the 1972 re-election campaign. Dean advised Caulfield to secure the advice of an attorney because such a plan was filled with legal problems. In the meantime, Caulfield discussed his proposal seriously with Joe Woods, Mike Acri, Roger Barth, and Tony Ulasewicz. Joe Woods, the brother of Rosemary Woods, was a friend of Caulfield's from the 1968 campaign, whom Caulfield envisioned as the vice president of the new corporation who would head up the Chicago office. Caulfield also says he discussed the proposal with Rosemary Woods. He explained to her that he was interested in establishing a security entity and that, if he could get funding, he would be offering a principal position to her brother. Miss Woods only recalled that Caulfield came to her and explained that he wanted to set up, quote, sort of a PR, unquote, operation with her brother based in the Midwest. She testified she was opposed to the idea because she felt her brother was more qualified to head such a corporation than was Caulfield. Caulfield testified that Miss Woods had general knowledge that he could obtain information of a political nature, but that he never discussed specific details of Ulasewicz's operations with her. Caulfield said he requested Miss Woods' assistance in locating Donald A. Nixon on one occasion for Tony Ulasewicz. Miss Woods testified that she had no knowledge that Caulfield had an independent investigative capability in the White House. Caulfield also talked with Ulasewicz about forming a private security business. Ulasewicz's assignments had declined as 1971 progressed, and Caulfield had often talked with Ulasewicz about entering private business when Caulfield left the government. Caulfield envisioned Ulasewicz as head of the New York office of the new corporation, with primary responsibilities for offensive intelligence gathering. Ulasewicz subsequently rented an apartment at 321 East 48th Street, apartment 11C, New York City, that could be used as an office for the private detective agency. In the late summer of 1971, Caulfield met with Acri, Barth, and Joe Woods for about 2 hours at his home to discuss the proposal. Following the meeting, Caulfield told Dean of the group's plans, and Dean asked Caulfield to commit the proposal to writing. Caulfield then drafted the memorandum entitled, quote, Operation Sandwedge, unquote. The document called for an offensive intelligence gathering operation, which would be clandestinely based in New York, and would be able to infiltrate campaign organizations and headquarters with, quote, undercover personnel, unquote. The offensive capability would also include a, quote, black bag, unquote, capability, quote, surveillance of Democratic primaries, convention meetings, etc., unquote, and, quote, derogatory information investigative capability worldwide, unquote. In addition, the memorandum outlined an operating cover for the entity. The new corporation would hire itself out to large Republican corporations, whose fees would finance the clandestine and offensive capability envisioned in the memorandum. Caulfield emphasized the clandestine nature of the operation. The offensive involvement outlined above would be supported, supervised, and programmed by the principals, but completely disassociated, separate foolproof financing, from the corporate structure, and located in New York in extreme clandestine fashion. Caulfield noted in the memorandum that Ulasewicz would head the clandestine operation in New York, claiming that, quote, his expertise in this area was considered the model for police departments throughout the nation, and the results certainly proved it, unquote. Woods would be in charge of the Midwestern office of the new corporation, heading covert efforts and acting as liaison to retired FBI agents, quote, for discreet investigative support, unquote, from the FBI. Mike Acree would provide, quote, IRS information input, unquote, and other financial investigations that would help support the New York City operation. In testimony before the Select Committee, Caulfield claimed that, quote, black bag capability, unquote, meant the carrying of monies that might be collected in a political campaign. What I meant to propose by that was that Mr. Ulasewicz and anyone else that might be connected with such a proposed undertaking would have the capability to supervise the security of the carrying of monies which might be collected during the course of a campaign. However, earlier in his memorandum, on page 2, Caulfield discussed a former FBI agent who was known as a, quote, black bag, unquote, specialist, while at the FBI. Caulfield acknowledged that the term, quote, black bag specialist, unquote, meant an individual who specialized in breaking and entering for the purpose of placing electronic surveillance. In addition, Caulfield noted that the term, quote, bag job, unquote, in the intelligence community meant a burglary for the placement of electronic surveillance. Thus, it appears that the capability to which Caulfield was referring in his sandwich proposal was one of surreptitious breaking and entering for the purpose of placing electronic surveillance, quite similar in nature to the gemstone operation which ultimately evolved. This interpretation is further buttressed by the budgetary request for $15,000 for electronic surveillance equipment noted in the attachment to the plan that was submitted to John Dean. In August or early September 1971, Caulfield brought Dean a copy of the Sandwedge Memorandum. Dean testified that Caulfield wanted to discuss the matter with John Ehrlichman and Attorney General John Mitchell. Dean recalled that the memo provided for, quote, bag men to carry money and engage in electronic surveillance, unquote. On September 17, 1971, Caulfield wrote a follow-up memorandum to John W. Dean in which he explained how the new security corporation could handle the security needs for the 1972 campaign and the Republican National Committee. In addition, Caulfield had lunch in September 1971 with Dean and Magruder to discuss, quote, Project Sandwedge, unquote. Dean discussed the Sandwedge proposal with Attorney General Mitchell. Mitchell said he was not interested in the proposal since he felt that the principal problems of the re-election campaign related to security against potential demonstrators. In addition, Dean testified that Mitchell wanted a lawyer to handle any such operation. In his testimony, Mitchell admitted to being aware of the concept that Caulfield was proposing, but he also claimed that he had never seen a copy of the Sandwedge Memorandum. Mitchell did, however, talk to H.R. Haldeman about the Sandwedge operation, but said that Haldeman also disapproved of the operation because of, quote, the lack of experience, unquote, of the individuals involved. Mitchell did not, however, wish to discuss the proposal with Caulfield, and so Dean kept putting Caulfield off whenever Caulfield raised the subject. However, Caulfield also took the Sandwich proposal to John Ehrlichman. Ehrlichman testified that Caulfield brought him a 3 or 4 page double-spaced typewritten prospectus concerning the establishment of a private security entity. Ehrlichman said he told Caulfield that he could not help him on the proposal. However, Ehrlichman mentioned Operation Sandwedge to Dean, and according to Dean, said that he would like to keep Tony Ulasewicz around during the campaign, even though he did not think much of Caulfield's grant proposal. Dean testified that Ehrlichman also informed him that Mitchell and Caulfield should meet to discuss Ulasewicz's future. Because of Attorney General Mitchell's lack of enthusiasm for Caulfield's project, Dean let the matter ride and did not give Caulfield a specific yes or no. However, in the fall of 1971, it was decided to switch the payments from Kalmbach to Ulasewicz to a cash basis. Therefore, Kalmbach gave Caulfield and Ulasewicz $50,000 in cash in the fall of 1971, which was meant to fund Ulasewicz's activities at least through the campaign of 1972. By November 1971, Caulfield knew that his proposal was going nowhere. However, he wanted to work as a scheduling aide to Attorney General Mitchell in the upcoming campaign, and therefore asked Dean to get him an appointment with Mitchell. Caulfield met with Attorney General Mitchell on November 24, 1971, just prior to the Attorney General's meeting with G. Gordon Liddy. Prior to the meeting between Caulfield and Mitchell, Caulfield directed Ulasewicz to go to New Hampshire and investigate the primary campaign of Congressman Pete McCloskey. This effort was designed in part to gather valuable political information for the potential New Hampshire primary, as well as to show Attorney General Mitchell the capabilities of Caulfield and Ulasewicz. Ulasewicz investigated the McCloskey campaign in New Hampshire from November 18 through November 21, 1971. While in New Hampshire, he interviewed a number of campaign workers and volunteers in the organization under his usual pretext of being a newspaper reporter. Ulasewicz's report on the New Hampshire campaign was forwarded over to the Attorney General, along with some follow-up reports that were written after a subsequent visit to the McCloskey campaign headquarters 2 weeks later. Mitchell discussed possible employment in the campaign with Caulfield at their meeting on November 24, 1971. However, Operation Sandwedge may not have been turned off at this meeting because Caulfield continued to refer to his intelligence gathering capabilities as, quote, Operation Sandwedge, unquote. For example, in a memorandum dated December 11 through 12, 1971, Caulfield described, quote, a sandwedge-engineered penetration of McCloskey's volunteer headquarters in Washington, D.C., unquote. This refers to a visit by Ulasewicz to the McCloskey headquarters to obtain information. The memo also refers to future arrangements to infiltrate the New Hampshire McCloskey campaign. In late December 1971, Mitchell asked Dean for a summary of Caulfield's and his agents' activities. Dean wrote Mitchell on January 12, 1972, that Caulfield had prepared a list of the activities so that Mitchell could review them in order to decide whether or not further funding would be made available for Mr. Ulasewicz. Mitchell stated that this memorandum was the last discussion of Sandwedge and that the proposal was finally killed then. Ulasewicz continued to be funded through cash payments after this time, but his political investigations dropped off considerably until after the break-in at the Democratic National Headquarters on June 17, 1972. Operation Sandwedge, as envisioned by Jack Caulfield, was a significantly similar precursor to the Gemstone Plan, which was later implemented in the campaign of 1972. The plans calling for the creation of an offensive intelligence gathering capability were basically what the Gemstone Plan was designed to do. The placement of infiltrators in campaigns, surveillance of the Democratic Convention and meetings, the creation of a, quote, derogatory information investigative capability, unquote, and the creation of a, quote, black bag, unquote, capability, were the very measures that the Gemstone Plan in fact carried out. Discussions of the Sandwedge proposal appear to have continued until at least January 12, 1972, a mere 2 weeks prior to the initial meeting in Attorney General Mitchell's office, when the Gemstone Plan was first revealed. The relationship between the Sandwedge proposal and the Gemstone Plan suggested by Jeb Magruder's statement. In November 1971, it was indicated to me that the project, Sandwedge, was not going to get off the ground, and consequently, G. Gordon Liddy came into the picture after that. 3. Other surveillance. Senator Edward M. Kennedy. Following his investigation of the accident at Chappaquiddick, Ulasewicz kept Senator Kennedy under physical surveillance on a selected basis. In the fall of 1971, John Dean testified that he received a call from Larry Higbee, who said that Haldeman wanted 24-hour surveillance placed on Senator Kennedy and regular reports of his activities forwarded to the White House. Dean passed the request to Jack Caulfield, who emphatically stated that he thought 24-hour surveillance was a silly idea. Caulfield contended that it would require several men and might result in Senator Kennedy discovering he was under surveillance. In addition, the 24-hour surveillance could be easily misinterpreted as a threat on his life, and the police or FBI could be called in to investigate. Dean agreed with Caulfield's assessment of the idea and convinced Higbee that the plan was unwise. As an alternative, Caulfield was directed to keep track of Senator Kennedy's activity and to pursue specific investigations that could turn up valuable political intelligence. As a result, many of the investigations listed above, conducted by Anthony Ulasewicz, were a result of this original directive from Haldeman. Other investigations of Senator Kennedy. There were other instances of White House-initiated investigations designed to discredit a potential presidential bid by Kennedy. In the summer of 1969, John Dean, then at the Justice Department, testified that he was instructed by Deputy Attorney General Richard Kleindienst to contact Cartha Deloche, Deputy Director of the FBI, and, quote, obtain from him information regarding the foreign travels of Mary Jo Kopechne, unquote. Kopechne was the woman who died in the Chappaquiddick auto accident. Kleindienst told Dean that the White House wanted this, quote, very important information, unquote. Dean obtained the information and passed it on to Caulfield at the White House. Dean was not sure why he was asked to be the courier of the FBI information, but he speculated before the Select Committee that he was chosen, quote, so that others could deny they had done so, should the matter become known, unquote. In another incident, in about July 1971, E. Howard Hunt, who was working part-time for the White House, discussed investigating Senator Kennedy with his employer, Robert Bennett, of Mullen & Company, a Washington, D.C. public relations firm. Hunt had been advised by Colson or Bennett to investigate Senator Kennedy's activities. Hunt had asked Bennett if he knew people with information on the Kennedys, and Bennett mentioned Clifton DeMotte, a General Services Administration employee in Rhode Island, who had worked in John Kennedy's 1960 campaign and was, Bennett believed, antagonistic toward the Kennedy family. Although Bennett testified that he warned Hunt that DeMotte might not know anything politically useful, Hunt says that he told Colson that he had been given, quote, credible information, unquote, that DeMotte was worth contacting. Hunt says Colson asked him to interview DeMotte without disclosing Hunt's White House connection. Hunt said he would need an alias, false documents, or perhaps a physical disguise for the interview. Hunt testified that Colson was wary of approaching the FBI or the Secret Service with such a request, and so he agreed to, quote, look into, unquote, obtaining the material from the CIA. General Robert Cushman, formerly Deputy Director of the CIA, testified that on July 7, 1971, he received a telephone call from Ehrlichman, in which Ehrlichman said, quote, Howard Hunt has been hired as a consultant to the White House on security matters, that he would be coming to pay me a visit, and could I lend him a hand, unquote. Alleged notes taken by Cushman's secretary during the telephone conversation show that Ehrlichman explained that Hunt was working for the president and should be given, quote, carte blanche, unquote, by Cushman. However, Cushman denies hearing any such language by Ehrlichman during their conversation. Hunt subsequently obtained the disguised materials, a driver's license, a wig, and a speech-altering device, after a meeting on July 22, 1971, with Cushman. Hunt testified that he then went to Rhode Island on or about July 28, 1971, and, in disguise, interviewed DeMotte. Colson and Hunt decided that the information obtained in the interview was, quote, useless, unquote. In another incident, Watergate figure Alfred Baldwin testified that he was assigned by James McCord to monitor visitors to Senator Kennedy's senatorial office for a brief period in May 1972. The purpose of the surveillance, Baldwin testified, was, basically to determine what groups were in the area of the senator's office, unquote. End of section 11. Recording by Warren Cotty, Gurnee, Illinois.